Hi there. Welcome to Conservation Conversations. This is where we dive deep into the trials and triumphs of conservation in Africa. And on this journey, we'll be dissecting Africa's conservation challenges and uncovering some really cool homegrown solutions. I'm your host, Elizabeth Gitari Mitaro. Today, I want us to have a conversation about mining and the rights of landowners and mining companies in Kenya. We've received quite a number of questions and requests for an analysis around the Mining Act and what that looks like, especially given the juxtaposition of mining and minerals rights versus wildlife conservation and biodiversity conservation. What takes precedence when you have both occurring in the same ecosystem or on the same piece of land? Are you, as a landowner, entitled to deny someone access to your land in respect to a mining license? What are the rights in respect to potential mining companies? Potential mining by companies or other people or organizations, prospecting licenses, and that sort of thing. So let's have a look at what the law says and where you fall. So let's start by defining what are minerals and who do they belong to. So if we start with the highest law of the land, the Constitution, we can see from Article 62, subsection 1, subsection F, that all minerals are classified as public land. What does this mean? That all minerals belong collectively to the people of Kenya and managed on their behalf by the government or the state. All right? So it doesn't matter whether the minerals are on land that is owned by the government or on land owned by the community or on land owned by you as a private citizen with a title deed. If you find minerals under your land, you do not own them. Those minerals belong to the government of Kenya. So how do we then end up with mining, with people with mining licenses? How do we make money from mining? What is the actual infrastructure? So in Kenya, we have what we call the Mining Act of 2016. And one of the things that I'd like us to go through is a review of all the possible licenses that one can get from the actual from the infrastructure provided for by the Mining Act. All right. But before we go to the licenses, in terms of administration, you have the Cabinet Secretary who's in charge of mining with clear responsibilities for administration of the Mining Act, powers to develop policies, regulations, and all that. And then you also have the Directorate of Mining as well as the Directorate of Geosurveys or Geological Surveys. And all these directorates assist the Cabinet Secretary in the administration of, the mining sector and the licensing functions, so on and so forth. So what are some of the licenses that one can acquire under the Mining Act? We first start with what is called a reconnaissance license. A reconnaissance license is available to a citizen who is above 18 years, is of sound mind, has the prescribed technical and financial expertise in mining. It can also be given to a body corporate, but it has to be registered and established in Kenya. And essentially, the reconnaissance license is given for a specific area, which minimum is 1 block and I think a maximum of 5 blocks, 5 contiguous blocks. And one of the things about the reconnaissance license is essentially it is acquired or it is applied for people who just want to find out, to do a reconnaissance of an area, essentially, to find out whether there might be any mineral deposits within a specific area or not. Then secondly, you have what is referred to as a prospecting license. And the prospecting license is also given to any citizen who's above the age of 18, is of sound mind, or a body corporate that also must be registered and established in Kenya. Prospecting license is essentially a license that is given to the applicant allowing them to prospect for minerals, but not essentially to mine. So it is essentially a step above the reconnaissance license, and one is then allowed to sort of dig through or, have specific activities to prospect and to explore for the discovery of certain minerals. Now, any minerals that are found through that prospecting belong to the national government. There is a clear responsibility to report if there are any mineral discoveries that have been made, and that report must be made immediately upon that discovery to the Cabinet Secretary, all right? A prospecting license is also not transferable in any shape or form. So if it is given to company XYZ, then it is only company XYZ that can conduct the prospecting, essentially, right? There is an opportunity to renew the licenses if one wants, and essentially must be renewed 3 months before expiry. And these licenses are essentially given for a maximum of 3 years. So you cannot get a prospecting license for, say, 10 consecutive years. So after the 3 years are over, 3 months to the expiry of that time, if you want a renewal, then you have to make an actual, application for renewal, right? And you need to relinquish your current prospecting license before you are issued with your renewal, all right? The minimum number of blocks is about 125. And there is also an issuing of contiguous prospecting licenses for blocks that are contiguous to one another. Then there is also what is called a retention license, and the holder of a prospecting license can then apply for a retention license if he or she or the organization has identified an actual mineral deposit with potential for commerciability, but that deposit cannot be sort of extracted or developed immediately. So remember, in the prospecting license, there's an obligation to report immediately, deposits are found. But if you're not able to commercialize that immediately, then you can apply for a retention license, essentially for the duration of time that it would give you. And it's given for a maximum of 2 years. So you're given an additional 2 years to figure out the commercialization, as it were, of the deposits that you have found. Then there is then what we call a mining license. And the mining license is also given to persons above the age of 18 who are of sound mind, or if it's a mining company, it has to be a corporate body and it has to be registered in Kenya. And so many of the foreign companies that you find that they are mining in Kenya are just essentially subsidiaries of international corporations, but they have their own distinct legal identities and corporate identities, and they are registered under the Companies Act of 2014. All right? So a mining license cannot be issued in respect to land that already is subject of a reconnaissance license, a prospecting license, or a retention license. The only time that can happen is under two conditions. One, the person who's applying for the mining license is also the holder of the various other licenses in respect of that land. So what does this mean? Let's take the example of Peter. Peter has a reconnaissance license and a prospecting license and a retention license in respect to LR number 47, land number 47. So if a person, John, wants to get a mining license in respect to that particular piece of land, he would need consent from the holder of the other licenses, all right? So this ensures that there is a control of hostile takeovers or essentially hostile takeovers of mining blocks and mining licenses by competitors, essentially, all right? These licenses are issued for a maximum of 25 years or a forecast life of the mine, whichever is shorter. So when you're making the application, you then project what the life of the mine will be. If it is higher, if it's longer than 25 years, then you reduce. The license is only issued for 25 years. And it is renewable for a maximum of 15 years or the life of the mine, whichever is also shorter. Now, immediately one is issued with a mining license, they have to commence work within 6 months of receipt of the mining license, which is why people apply for retention licenses, so that then you don't find yourself being overtaken by the clock in terms of that 6-month period. So the retention license gives you time to put your financial and economic affairs in order to ensure that you're now able to apply for a mining license once you get the mining license, you're now able to hit the ground running within 6 months of issuance of that particular license, essentially. Now, there is a clear responsibility on the holder of a mining license to notify the Cabinet Secretary if they suspend mining operations for 6 months, or at the very least 3 months, all right? Or if they curtail the mining for 1 month, or otherwise within 3 days of halting any of the mining events. This is to ensure that, because the minerals, like we've said, are managed in trust, are managed by the government in trust for the people, because they belong to all of us as Kenyan citizens. And so that's essentially the direction that takes. And these licenses that we've just covered are essentially for large-scale projects, but there are also small-scale operations that require licensing. So let's have a look at what that looks like. So for small-scale operations, you can get a reconnaissance license as well, a prospecting permit, a mining permit, all right? A reconnaissance permit, a prospecting permit, and a mining permit. Now, for the reconnaissance permit, they can only be issued to a citizen, obviously over 18 with a sound mind, or a corporate body that has at least 60% shareholding by citizens of Kenya, right? And if the rights for the mineral reconnaissance are over community land, then there is a requirement to get consent from the community land administrators. If it's in county land, then get permission from the county government, especially if it's an alienated community land, then you need to get permission from the county government, and then obviously national government if it's on public land. Then next you have a prospecting license, still offered to citizens, sound mind, over 18, or if it's a body corporate, then must have at least 60% shareholding. And the Act is not very clear around any limitations that exist in terms of whether the prospecting permit rights are exclusive or non-exclusive. And then you also have the mining permit with the same sort of applications, but with a maximum of 5 years, as opposed to the mining license that has a maximum of 25 years, like we said before. Now, there is something that's also called local content in mining, and the Act essentially requires that the holders of these licenses and permits give preferential treatment to the maximum extent possible to materials, products, services, and workforce from Kenya. So ensuring that mineral rights holders must provide a detailed local content report, and the local content is a critical sort of condition for granting of the right to mine these essential minerals. Let's look at what consent looks like in respect to mining in the different land tenure systems as per the Land Act and the Community Act as well. So if we start with consent for prospecting and mining on private land, when we look at Section 37(1), a prospecting or mining right cannot be granted with respect to private land, essentially without the express written consent of the registered owner. However, the Act also says that such consent cannot be unreasonably withheld, and the consent is deemed given if the landowner has entered into a legally binding agreement with the applicant or the government, or an agreement regarding adequate compensation to allow for the prospecting and the mining to happen, all right? And so this consent cannot be verbal in nature, and it has to be in the form of a proper actual contract or agreement. What happens if it's on community land? We find this provision in Section 38, subsection 1 of the Mining Act of 2016. Prospecting or mining rights cannot be granted over community land without the express consent of the relevant authority. And the relevant authority here would be either the Land Administration Council under the Community Land Act, or the National Land Commission, or the county government in respect to unalienated community land, all right? And so the consent in this case is also deemed to have been entered into or given if the community has actually entered into a legally binding contract with the mining right applicant, essentially. So these sections refer to adequate compensation agreements for both private land and community land. And Section 99 tells us what compensation looks like. So when we look at Section 99, we see that where a permit is granted in a designated area to a person who is not the owner of that land, then the holder of that permit that has been given shall, which means he must compensate the owner of the land in the prescribed manner. And if they have an agreement, then it has to be in accordance to the agreement that they have put in together. So what are some of the mining company's rights? We've looked at the rights of the landowner, so let's look at the rights of the mining company. Number one, we find it in Section 15 of the Act that allows the Cabinet Secretary to restrict or exclude certain areas from mining operations to protect public interest, including environmental protection and land rights of local communities. So it's not automatic that if a mining company applies for a prospecting license or a mining or any of the other licenses and permits that we've talked about, that they would essentially be automatically granted, because Section 15 offers or provides the Cabinet Secretary with now the power to restrict that issuance based on those 2 points that we've talked about. So in addition to the issue of consent and the unreasonable withdrawal or withholding of consent, Section 40 has an interesting provision that if a landowner unreasonably withholds his consent, then the Cabinet Secretary has the power to institute compulsory acquisition procedures to compulsorily acquire the land from that particular landowner, especially if the consent is withheld contrary to, national interest, essentially, and then vest that land in the government so that the government now becomes the new landowner and is able to give the consent as it requires. Now, the Cabinet Secretary is also required by Section 34 to give notice of all pending applications to all landowners who are affected in terms of the reference land, or communities or relevant county governments, and provide the process of publishing notices and handling of objections to the issuance of these to the issuance of these permits or licenses that have been applied for. In terms of obligations of the mining companies, it must be Part 11 of the Act, mandates all mining companies to adhere to environmental, health, and safety regulations, and all mining companies and essentially holders of mining licenses or prospecting licenses and so on and so forth are required to actually conduct environmental social impact assessments and essentially get all of the necessary approvals from the National Environmental Management Authority before they commence operations and before they commence the activities in respect to their respective licenses or permits that they have gotten. Now, there have been some recent developments or attempted amendments to the law as of December of last year through a regulatory impact assessment that was prepared by the State Department for Mining pursuant to Section 6 and Section 7 of the Statutory Instruments Act. And essentially, this regulatory impact assessment was in respect to the mining dealings in minerals amendment regulations of 2023, mining license and permit amendment regulations of 2023, and the mining mine support services amendment regulations of 2023. Now, this report primarily focuses on the need for regulatory impact assessments, or RIAs, to evaluate the effectiveness of the amendments in addressing the policy issues outlined in the various regulations. And so in terms of alternatives to the proposed regulations, the text discusses, status quo options and maintaining the current regulations. One of the biggest proposals in this 2023 RIA report was an amendment to the Mining Act that would essentially remove the requirement for landowners' consent when applying for prospecting licenses. What this means is that the proposal was saying, so currently in the law, one of the documents that one needs to submit when applying for a prospecting license is a consent agreement or a written consent from the owner of the land if the person who's applying is not the owner of the land. So let's go back to our example. If John or John Limited, all right, if John Limited was a company that wanted to apply for a prospecting license in respect to land reference number 47 that is owned by Mr. Peter, John Limited needs to have a written agreement with Mr. Peter that Mr. Peter gives consent for John Limited to apply for a prospecting license in reference to LR 47, which is Peter's land. Now, this proposed amendment is essentially removing that requirement, which means that John Limited can apply for a prospecting license from the government of Kenya in respect to LR number 47 that belongs to Mr. Peter without giving notice to Mr. Peter and without getting the consent of Mr. Peter, essentially. And so this provision is raising significant concerns amongst landowners and stakeholders because everyone now is quite worried that, we will have people and companies applying for prospecting licenses, and suddenly you are woken up at 6 a.m. with someone, talking about they have a prospecting license in respect to your land and you are not consulted in any shape or form. So as of today, which is mid-June of 2024, this particular proposal has not yet been passed, although it is still a proposal that's going to be tabled before Parliament. And so one of the things that you would also want to participate in is put in your reviews and your memoranda and opinions on whether or not you agree with this change in the process. Now, the legislative process in Kenya involves several stages, and this includes, the public consultations, the parliamentary debates, the appearance before the parliamentary committees, before the actual passing of the bill or the amendment in Parliament, and presidential assent. So these particular proposed changes have not gone through all of that process to its completion. What does this mean? That landowners currently still have the right to deny access to their land for mining activities unless they provide consent and receive fair compensation for that particular consent, and that mining companies still must obtain the necessary licenses and secure the landowner's consent while complying with all the legal and environmental regulations that are required for this application. So over and above this, if you would like to learn how to put together really impactful scripts in writing your memoranda, we have a course that's coming up for you that is really tailored to equip you with the necessary skill set in putting together your memorandum, your opinions in respect to some of these changes in law. So we have a really good course put together and training workshop called Legal Analysis and Memorandum Writing for Effective Policy Advocacy. It's a one-day training that is going to run on the 1st of August from 9 a.m. to 5 p.m. It will be physically at a hotel in Nairobi, and the details will be sent to everyone who confirms for the course. And essentially, what we are seeking to do with this particular course is to equip you with the skill set that is required or necessary for the analysis of legislative amendments, legislative reforms, and policies. We're going to equip you with the skill set necessary to write impactful scripts to use in the analysis of legislative documents. We're going to offer you the support on how to write your memorandum and your opinions with credible evidence. We're going to equip you with the actual language to use in this process. We're going to provide you with tailored templates and assist you in communicating your opinions and your essentially your opinions and your input into some of these legislative processes, so that you don't only have the conversations just by yourselves in your offices or with your friends and families, but when you're writing the memorandum and then you're putting together the memorandum and submitting it to government, it is actually impactful and useful in a way that government or the people who are actually receiving it will not be in a position to say, oh, these people have only told us what is wrong with the law. They haven't provided any suggestions. They are just giving examples, but they're not providing the evidence, or the evidence is not credible, so on and so forth. So we're going to really essentially equip you with a skill set to put these things together. What is your investment? 15,000 shillings for all your meals for that day, for the room that you will be in, for the training materials, and for an impactful 8 hours with like-minded individuals who you can collaborate with in these advocacy processes. Now, we have very few slots for this course, essentially because we want to make sure that the course is impactful and practical, and we can only do this in small cohorts. So the first cohort is only for 20 people, and slots are filling up quickly, and the deadline for registration is on the 20th of July, and registration is confirmed by payment of the full amount. We're going to link the payment details and the cost details in the show notes below, but you can reach out to us through any of our social platforms, whether on LinkedIn or on Instagram or on X, wherever, or even on email, and we'll be able to answer any questions that you might have in respect to this. And that's all the time we have for today on Conservation Conversations. Thank you so much for tuning in. I really do hope that you've learned something new and that you actually feel empowered to take action towards a more sustainable future for all of us. Remember, even small changes make a huge difference. This conversation doesn't stop here. Please do connect with us on our social media channels at greenbrief_KE and at Liz Gitari across all platforms. We'll put all the links in the description box below. Until next time, keep well and keep changing the world.